Hello everybody, I'm Stephen Bush with the Bush Law Group, talking with you today about post-loss obligations, and our fourth post-loss obligation that we're going to be talking about today is proofs of loss. Proofs of loss is one of my favorite things to talk to people about, especially contractors and public adjusters, because proofs of loss are very powerful. They're a very powerful tool that can be used. So let's jump right in today on proofs of loss. What is a proof of loss? Let's talk about that first. Let's start there. A proof of loss is the policyholder's proof of the loss, right? So usually you get a form from the carrier, and I want to stress this to you right here. Use the carrier's form. Don't use your form, don't use Xactimate's form, don't use a form that somebody made up. Use the provided form by the carrier. Now you may say, why? Well, I'll tell you why. We're talking about post-loss obligations, right? All right. Under the post-loss obligation to provide a proof of loss, either when requested or when required, and we'll get into that in a minute, there are certain requirements that proof of loss must contain, certain information it must contain in order to comply with the terms and conditions of the policy. If you use a proof of loss that does not have everything that particular policy requires, information, right? Because that's what it is. A proof of loss is information. If you don't have all that information that the policy requires, your proof of loss is no good. It can be rejected because it's technically deficient. So my suggestion, always use the carrier's proof of loss. I keep a bank of proofs of loss, so when I get a blank one, I just scan it in and I put it into my little bank of proofs of loss, so when I need one, I just go there to get it. And I don't have to try to beg the carrier for one, even though they're supposed to provide it and they never do. I can go to my bank of proofs of loss. So what should go with the proof of loss? A proof of loss should have every blank filled out. I do not like for you to put things like TBD, to be determined, on a proof of loss. Why? Because you haven't given the information. Again, that's technically deficient. Fill all the blanks out to the best of your ability. If you don't know, and I'll give you a great one that happens all the time. Carriers nowadays in this environment, they don't want to provide the insurance policy. So a lot of the information that goes on the proof of loss, you have to get from the insurance policy, but you don't have it, right? So here's what I put in that blank. I just put a big star, and then down at the bottom, I put a big star so it's identifiable. And I say, carrier has failed to provide the policy as requested, cannot provide information. That's all you have to do. But don't put in there unknown or anything like that. Try to answer as much as you can in the proofs of loss. It's very important that you do that. Now, once you've got all the information, the data, you should submit with the proof of loss your Xactimate, your scope of work, the scope of the damages, any and all photographs. If you have bid items, you need to submit those bid items with that proof of loss. Why? Because it's proof of the loss, right? So compile all that information and send it in to the carrier. It's very, very important. Now, when should you send in a proof of loss? I love to send a proof of loss in as soon as possible. As soon as possible. As soon as, and you have to remember, I was a public adjuster for many years, and I did proofs of loss. And I would always send it in as soon as I could get all the data and all the information, as soon as I had completed my investigation of the loss. And I knew exactly what it was going to take to restore the policyholder back to their pre-loss condition. I took all of that, put it together in proof of loss, and I sent it in to the insurance carrier. Now, some states, some jurisdictions, I was talking with Galen, who is a policyholder attorney in Louisiana, and he said, Louisiana, maybe not so much. And Louisiana is kind of its own beast, right? Because they don't really follow the laws of the rest of the state. They kind of have their own laws. So we're going to set a Louisiana out to the side. And what I am going to tell you is because this could be jurisdictional, check with your local attorneys that handle your lawsuits for you in your state, all right? But I've never seen in a jurisdiction where, other than Louisiana, where sending in a proof of loss early on hurt the policyholder. It always helps. And in many jurisdictions, it starts the clock ticking. all right? Because like in Florida, they have 60 days. The date that they receive that proof of loss, they have to make a determination within 60 days of the claim. Other states have something similar to that when the proof of loss is submitted. So, when should you submit the proof of loss? There are two types of clauses that I've seen in insurance policies. One clause says that you are required to send it when we request it, right? 60 days after our request, you need to send in a proof of loss. The second clause says you are required to send in a proof of loss 60 days after the date of loss. So one is on request and one is a must send, So you need to know what policy you're dealing with. Two insurance companies in particular that pop up that most everybody works with is Allstate and State Farm. Those policies require a proof of loss within 60 days of the loss. So they don't even have to request it. You have to send it in, and you should do that. But I like for you to send in those proofs of loss even if they don't request it. And it kind of ticks them off, but that's okay. Because when you send in that proof of loss, you know why it ticks them off? Because now you're putting the pressure on the carrier to make a determination and to make the policyholder whole. So they should do that. All right, now, let's talk about what happens when the policyholder fails to send in the proof of loss. Most jurisdictions have established that a policyholder's failure to provide a proof of loss can be fatal to the claim. I got a call, as a matter of fact, on my way out here to Arizona to meet with Anthony and his team, and it was from a contractor in North Carolina. And he said, hey, I've got this claim, and the adjuster says he's not gonna release the funds or pay the claim unless we send in the proof of loss. Can he do that? And I said, well, maybe. Did he ask you for a proof of loss? He said, no, it's required under the policy. I said, well, then of course, you've got to send it in. Why? Because the policy requires it. That's what creates a burden now on the carrier to perform. Why? Because that's all duties under the insurance contract are. They're just performance duties. The policyholder performs, and then the carrier must perform. And then the policyholder performs, the carrier performs. So, proofs of loss, they're so important. And the last thing I want to talk to you quickly about a proof of loss is reserving your right under the proof of loss to supplement. I got into a lot of trouble early on as a young attorney when I went to deposition of my client. We had an Allstate policy, and we complied with the post-loss obligation and provided the carrier with the proof of loss. And I don't remember the numbers exactly now, but let's say they were somewhere around $80,000 is what the initial proof of loss was. So I sent out a contractor and I said, hey, give me a real good number for this. You know, write up me an exactimate so I know what this loss really is. And so the contractor came back and it was like $100 and something thousand. And I said, what? How is this possible? Because we had an estimate that was 80 something thousand. And he said, well, here's why, because I found all this additional damages, right? So I, being a good attorney, did a supplemental proof of loss, and I supplemented it for that additional dollar amount. Well, when I got to deposition with my client, the defense attorney, who was a very aggressive, very nasty defense attorney, he went after my client and said, but you swore on this date that the loss was 80 something thousand dollars, didn't you? You swore it was $80,000 on this date, and now suddenly you're swearing that it's 120 something thousand dollars. And he was like, so which is it? Well, you know, naturally I was objecting right and left, and he and I got into a little bit of a tussle, but we won't get into those semantics. But the point is, if I had just reserved my right under the first proof of loss, I could have said, look, knucklehead, we reserved the right to supplement it, and we did it. So if you want that clause, contact my office. It's the Bush Law Group, and I will be happy to provide you with a clause that you can put on every proof of loss that reserves the policyholder's right to supplement or to provide a new proof of loss should additional information become available. All right? Happy to do that. Just reach out again at Stephen Bush at the Bush Law Group, and I'll be happy to help you. So, proofs of loss and appraisal. That's been a hot topic lately as well. Is a proof of loss required if the carrier invokes appraisal? Absolutely. If two things have happened: one, it's required under the policy, or the insurance company has requested the proof of loss, all right? So you need to make sure that if you're dealing with an appraisal situation that you have complied with all post-loss obligations before the appraisal takes place, or that you get it complied with as soon as possible, right? Comply with these post-loss obligations so that when the appraisal award comes out, your client can actually get paid. There was a recent case in Florida that held that appraisal is premature. All right, appraisal is premature when the policyholder has failed to meet the post-loss conditions of the policy, requiring that the policyholder provide the carrier with a proof of loss. So you have to look at these things and you have to know what they are. So let's do a quick recap. We're talking about just 5 post-loss obligations. There are more post-loss obligations under the terms and conditions of the policy, but we're talking about 5 right now. First one, give prompt notice, right? Second one is to cooperate, show the property. Third one is to mitigate the damages. The fourth one is the proof of loss requirement. And in just a second, we're going to come back and we're going to talk about the fifth one, which is examinations under oath. And you don't want to miss that one because there's a lot of juicy information in there. So I'll see you in just a second for our last post-loss obligation, examinations under oath.